Welcome to those that are joining us right now for today's webinar on buying and selling tenanted properties. It'll just be a few moments before we get started. I just want to let people get settled in. Again, just welcome to those that are coming in. We are going to get started in just a few moments, just letting people get settled in. Okay, so it looks like most people have got settled in, so that's great. Thank you all today for joining us and joining me on this webinar on buying and selling tenanted property. Before we get into kind of the meat of today's topic, just a few notes. You can change the way you're viewing the webinar by looking at the video settings and changing the ratio as to how big you want the slides versus the video of me. You can also ask questions through the Q&A tool, and you'll see this in the toolbar there. So feel free to ask your questions at any time during the webinar, but we will get to them at the end. But as you're thinking of the question, go ahead and pop that question in so you don't forget it at the end. And like I said, we'll get to those at the end of the webinar. And also be sure to stay tuned for the end of the webinar because we are going to have a special guest in our Q&A session today. I know that most of you are members of Landlord BC, but for those that are not members, if you want more information on becoming a member, you can reach out to our Director of Member Engagement, Kimberly Coates. She can be reached at toll-free throughout BC and actually Canada at 1-855-707-2366 or email her at kimberlyc@landlordbc.ca. Also like to take a moment to thank our sponsors. So today's sponsors is Waste Connections of Canada. Waste Connections understands that there are limitations on the increases you can put forward to your tenants, really if any at all. In light of this, Waste Connections would like to help you realize 20 to 40% reduction on your monthly waste and recycling fees. Additionally, for a limited time, they will waive the monthly fee on the first month, and this is valid through December of 2020. So again, this is a limited offer. You can call Rob direct at 604-834-7578. An important thing to note of fact is that 90% of members who call Rob at Waste Connections are able to start enjoying their savings right away. The worst thing to do is to wait and put it off and continue to be locked in your current agreement. So again, that's 604-834-7578 to speak to Rob at Waste Connections. So moving into today's topic, we are talking about the buying and selling of tenanted properties. We're going to kind of go over what you need to consider. What are the important things to keep in mind when you are selling a property and when you are buying a property. And really, this is one of those processes, actually, I say one of these processes, like many things in this industry, it's something that it really helps if you have all the information up front. If you've asked yourself these questions up front before you actually go into the process so that you are aware of what you should expect and what the other party should expect and what your tenant should expect. When you come to the table with that knowledge, it sets the expectations of everyone to a higher bar, really. And that can really be helpful, especially when it comes to getting cooperation from your tenant, and also making sure that if you're selling it to someone, that they are aware of what they can expect. And if you're purchasing it, again, what they should expect from you. So when it comes to selling a tenanted property, we're going to go over things like what kind of notices to use to give your tenants when selling their rental unit that they're living in. We're going to go over what to do if your tenant is not cooperative, and what to do if the new owners want the rental unit to be vacant. When it comes to the buying side of things, we'll go over whether or not you're purchasing this is a revenue property or personal home. What happens if you purchase it as a revenue property? What does that mean for you? And what should you get from the previous owner? So when you're purchasing a property, what do you want? Aside from the property itself, what else should you get? So what do I need to consider? What do you need to consider when selling a tenanted property? And I mean, to be blunt, navigating a normal tenancy can sometimes be difficult. It's not always the easiest thing to do. But adding onto that, the prospect of selling a property, it can really kind of make your head spin. But the key is always knowing the fundamental rights that you and your tenant and the new purchaser have in place. So as mentioned, like I said, we're going to go over some of those things. So the first thing that we're going to cover is what type of notices do you serve your tenant when selling a unit? The quick and easy answer is none, or perhaps a few. It really depends on the situation. So listing a property itself is not a thing that requires any notice to be given to your tenant. So if you choose to go to your realtor and list your rental unit for sale, you should let your tenant know. In fact, before you even get to that point, hopefully you'll have a conversation with your tenant. But that's more out of courtesy and out of a coming from a wanting to make sure that you maintain a good relationship with your tenant. There is no notice to serve to just list it for sale itself. And obviously, if you need to show the rental unit, there's a type of notice for that, a notice of entry. And we're going to get to that in a bit more detail at the very kind of end of the webinar. We're going to talk more about just the buying and selling right now. So when it comes to the type of notice that you give, like I said, generally the answer is just listing it isn't enough to end a tenancy. If we look at ending the tenancy, so if you want to end the tenancy, well, we need to look at the type of notice that does exist, and that's specifically the 2-month notice if the new owner wants it vacant. And we're going to get to that in just a moment. So we go back to there's no notice. So the first thing to be aware of is if you're selling the property, you're not necessarily ending the tenancy. Ending the tenancy really comes down to what the new owner wants. And like I said, we'll go over that in a bit. So what we do need to do is try to make sure that your tenant is cooperative with the process. Selling the property is a difficult thing, as I've mentioned already. And one of the reasons it's difficult is that there can be great uncertainty for a tenant. They might think that, well, they're going to have their rent raised, for example, or that their tenancy is going to come to an end. And when there's uncertainty in a tenancy, and when a tenant feels that type of uncertainty, there's a greater risk that they might not necessarily be cooperative with your process of maybe taking photos, getting assessments, showing the unit. So before you even really get to that point, really the first step is having a conversation with your tenant, explaining to them this is what you're wanting to do. You're going to be putting the property up for sale. And as part of that, we might end up having to show the unit to a couple of people. We might have to have an inspector come through. We may need to come through and take some photos. By having that conversation up front, what you're trying to do is get them on board with the process, get their buy-in to the process. And before COVID-19, I would answer this as, go over with a pizza and such and have that sit down conversation with them. Obviously now we live in a different world, so you're not going to go over with pizza and have a face-to-face conversation, but have a phone call or better yet, have a video call. Seeing people's faces definitely can help in that, and try to put their potential fears at risk. The first thing you can tell them is that the rent won't go up just because the property is being sold. There isn't a notice of rent increase that really applies to that. When we look at the other fear, the fear of ending the tenancy, you can say, well, at this point, we're just listing the property, which in itself isn't a reason to enter tenancy. So we can say that your tenancy won't be ended just for this. But if the new owner does want to have the unit vacant, you'll be given as much notice as possible and at least 2 months notice before the tenancy needs to come to an end. That might hopefully that will help kind of assuage their fears and make sure that they're aware that they do have rights regarding this. You can also let them know that if we serve that 2-month notice, they'll be getting 1 month compensation, which can hopefully go a long way in helping them accept the fact that the tenancy may come to an end. The one thing you don't want to do is set false expectations. So don't say the tenancy will not come to an end necessarily, but you can say that it's really dependent on what the new owner wants, whether or not they're going to be living in the unit or not. And again, we'll get to that in a moment. It also, of course, depends on the type of tenancy they have. If they have a fixed term tenancy, for example, so they've moved in maybe a few months ago and they have a 1-year fixed term, well, the tenancy won't come to an end before that date, at least anyway. So they do have that protection. Again, it's just about setting those expectations and letting them know that, yes, this may be a possibility, but if it is, they will have that advance notice. They'll be given as much warning as possible, and they will be getting that compensation of at least 1 month, which hopefully, again, can help with that. And again, like I said, you don't want to set those false expectations, because when you do end up having to end the tenancy, if you do have to end up ending the tenancy, you can end up in a situation where if you said it wasn't going to end, they're going to be quite upset. It might not necessarily want to cooperate with you at that time. So what happens if you've done all of this and your tenant is still not cooperative? They're not letting you in for showings. Perhaps they've left the unit quite messy, so it's not really suitable for showing the unit. What can you do about that? Well, essentially, in a situation like that, they're hindering your lawful right, which is something that is protected under the Residential Tenancy Act. And when that occurs, you can start by giving a caution notice. And again, we hope that you can resolve things through a conversation and just by communicating with them. But if you aren't able to, we move to a caution notice. And unfortunately, if it continues after that, we may end up having to look at ending a tenancy, which is a severe step, certainly, and not something that we would say you want to jump at hastily. But if the situation does seem to merit it and your communication doesn't really work to resolve those types of issues, then again, it comes down to potentially having to give a notice to end tenancy. Before you get to that point, you want to make sure that what you are doing is correct. So of course, one of the key things is entering a tenant's unit. If you have to enter a tenant's unit, you must make sure that you're giving proper notice. So that means giving a notice of entry at least 24 hours in advance. And when you give a notice of entry at least 24 hours in advance, that's giving it to them in person. If you post it on their door, you have to add an additional 3 days. Like I said, at the end of the webinar here, before we get into the Q&A, we'll go over some of the more kind of time-specific things with notices of entry and such regarding COVID-19. So what if your tenant lies to a purchaser? You've shown the unit to a potential purchaser, and they say, "Oh, it's really a dump, and there's rats everywhere, and the previous owner hasn't been taking care of it," and that is not the case. They're clearly lying about that to potentially try to throw the sale, so that again potentially they don't have to move. If a tenant lies to a potential purchaser, and that in a way that hinders your ability to sell the unit, again, that kind of goes back to that notice to end tenancy. And in fact, it does go back directly to the notice to end tenancy. When we look at the 1-month notice to end tenancy, there is a reason to end a tenancy on there that is specifically tied to lying to a potential purchaser. Now, this is not common. And truthfully, like I said before, hopefully this isn't even an issue because you've gone through that initial process of communicating with the tenant, of setting this up positively to ensure that they're on board with the process. But if it does get to that point, again, we can look at that notice to end tenancy if it really is that serious. So then what do we do if the new owner wants vacant possession? Well, the first thing we need to do is determine whether or not you can actually offer vacant possession at that time. So as I mentioned before, we'd have to take a look then at the type of tenancy agreement that's in place. In British Columbia, we have 2 general types of tenancies. There is a month-to-month or periodic tenancy and a fixed term tenancy. On a month-to-month tenancy, the 2-month notice can be served pretty much at any time, so long as the reason for serving it is applicable. So if the new owner is going to move into the unit, we'll get to that in a moment. The other type of tenancy is a fixed term tenancy. And there's always some confusion around fixed term tenancies. But in general, what a fixed term tenancy is a tenancy where both the landlord and tenant are agreeing that this tenancy will last for at least a specific period of time. Generally, that's a year or 12 months. And though it could be shorter and it could be longer. So when we look at that fixed term tenancy, what that states is, again, like I said, a landlord and tenant are both agreeing that this tenancy is not going to come to an end till at least a specific date, that 12 months or a year or 18 months, however long it might be from the start. And so what that does is limit you from being able to end that tenancy through this type of notice, through a 2-month notice. The earliest that tenancy could come to an end would be the end of that fixed term. So if we're looking at that and we have a fixed term tenancy and there are another 8 months or longer or however long it might be left on that, that's an important thing that you need to be aware of, and also an important thing you might need to communicate to your realtor and then to potential purchasers that the earliest that we can enforce a notice to end tenancy is, and whatever the end of that fixed term is. The next part of assessing this is, why does it need to be vacant? If it needs to be vacant because the new purchaser just wants it vacant to rent it out to someone else, well, you won't be able to provide that. And the new purchaser can't request it either, technically. They might make the request, but it's not a valid request under the legislation. So when we look at that notice, it states that you as the existing landlord can serve this notice on behalf of a new the purchaser, a new owner, if the new owner or their close family member intend to reside in the rental unit. And they do have to reside there for at least 6 months. It's also important to note that when we say close family member, and in general, if we're talking in residential tenancy terms, when we talk about a fixed, a close family member, what we're talking about is a parent or child of the landlord or the landlord's spouse. So it can't be used for siblings. It can't be used for aunts, uncles, grandchildren. Don't apply under that. It is very specifically just parents or children of the landlord or the landlord's spouse. So, and hopefully the purchaser has a realtor who's informed them that that is a requirement as well. So if they aren't just going to ask it unless they do in fact intend to move in. So, but it also is important that you ask that question and that you get something in writing from the new purchaser or the new owner that they do intend to live in the units, that you can say, okay, I'm giving this notice in good faith. It's also important to note that this notice comes with we mentioned that it does come, of course, with that 1 month compensation, but if the notice is not followed through with, it also comes with additional compensation, a penalty really, of up to 12 months rent paid to the tenant should the new purchaser not want to move in. So if they said they were going to move in and then they don't, they can be on the hook for an additional 12 months compensation. So obviously that can be quite significant when we're looking at rent of, really at the low end, $1,000, but maybe $1,500, $1,800 or $2,000 a month. That adds up really quickly over 12 months. So that's something to be very aware of. Now that does mean generally that it's the new purchaser that pays for that, but you want to make sure that you're aware of that as well, that is a potential liability when looking at this. So what if there is if the agreement that's in place is a fixed term? How do we get around that? We don't necessarily get around it. There is the 2 month notice can't be ended earlier than that when there is a fixed term tenancy. The only kind of exception to this is if both parties come to a mutual agreement to end tenancy. So a mutual agreement to end tenancy is exactly that. It is an agreement and it is mutual. Both parties need to come to the table in agreement that they want this tenancy to end. And you need to be careful when using this. It's not about pressuring the tenant to sign anything. And in fact, you don't want to do that. If it turns out that you did pressure the tenant to do this unduly, then that might end up invalidating that notice. So again, we don't want to do that. But if it is mutual and both parties agree that it's a good idea to end the tenancy, and that might mean offering some additional compensation as well, then that is an option as well. And either you can do that on behalf of the new owner, or the new owner can do that when they take possession and become the landlord. So if you've served notice, what do you do? What happens after you've served that notice? Well, if you've served the 2 month notice, hopefully the tenant will leave at the end of the 2 months notice. It's also important to note that when you serve that notice, as soon as it's served, the tenant can turn around and give 10 days notice to leave earlier. And that's if it's on a month-to-month tenancy, of course. So again, when you serve that notice, they can turn around and give you 10 days notice and leave earlier. That does not preclude them from getting that compensation. So if they give you that 10 days notice, they still get that 1 month compensation. Generally, that compensation is provided in form of just the last month's rent. So they generally just don't pay that last month's rent. But if they leave earlier, then you may end up having to pay them that compensation. So before you go into this process, you want to make sure that you have that money available, that you can pay them that. and that you have that conversation with your realtor, who should have that conversation with the realtor of the other party, or the purchaser, to establish who is going to pay that, who pays that 1 month compensation. That should really be built into the sale agreement or the purchase agreement. So again, moving on then, if you've served that notice, it's pretty standard from there when it comes to enforcing it. The tenant has a period of time to dispute that notice. It's 15 days. If they dispute it, then you'll go to a hearing, very similar to pretty much any other notice to end tenancy. And if you go to a hearing, then you're going to have to supply some evidence. That's where it becomes important to have something from the new purchaser saying that they're going to move into the unit. If the tenant doesn't dispute it, but you think the tenant isn't going to move out for whatever reason, if they've said, I'm just not moving out, or you can tell based on the fact they haven't started packing, that they're not going to move out, then you may want to consider applying for an order of possession. You don't have to wait until the end of the tenancy. So if the 2 month notice is given this month, so given within the month of November, and it's effective for the end of January, we don't have to wait till the end of January to see that they're not moving out to apply for the order of possession. We just have to wait for their time to dispute the notice to have elapsed. That amount of time, like I said, is that 15 days from the date that it is served. So when we look at that, we will, again, want to use that judiciously. We don't necessarily want to always just apply for an order of possession just because we can, but if we feel that that the tenant is not going to leave, then yes, that's a situation where you're going to want to apply. And waiting to the end isn't necessarily worth it, because you're waiting for a hearing at that point in time. So again, use that judiciously. Okay, so now we're going to move on to things that you need to consider when purchasing a property. So we're going to go into some of the more timely information about getting into the unit and such near the end, and relate that into COVID-19. So what do you need to consider when purchasing a property? Really, no one likes to kind of walk into a situation without knowing the whole story, and purchasing and tenanted property can really be exactly that. You're entering into a situation where in many ways you might be entering into a business agreement with a tenant, but not really have all the details. So it's important to make sure that your expectations are clear from the beginning. You want to ask the questions up front. It's never good to kind of end up after you've signed everything to say, oh yeah, I also might want this other thing. So it's important to kind of make a list up front. The first thing you should consider is, are you purchasing this as a revenue property versus a personal home? Generally, if you're looking to purchase a new property, you're going to have that in mind already. You're not just, most people generally don't just go out and purchase a property without having a purpose in mind. But nonetheless, that is the first question that you should ask. Do you intend on living in this unit, or do you have a close family member that you want to live in this unit? Or are you wanting to purchase this as another revenue property, or as perhaps your first revenue property? And each of these answers, depending on whether it's a revenue property or your personal home that you're going to live in, will have different outcomes. And again, the expectations from the other party will be different depending on how you answer that question. So what happens if you purchase the property as a revenue property? What does that mean? Well, it generally means that the tenants that are in place will stay in place. When purchasing a property as a revenue property, you are essentially purchasing the agreements. You're purchasing a business that is in place. And part of that business is those agreements that's in place, which means the tenants that are there will generally remain in place. And as mentioned, you're purchasing the agreements that are in place, which means all of the terms of that tenancy also remain in place. This means things like rent, the condition inspection, which hopefully was done at the beginning of the tenancy, the terms of the tenancy, things like whether or not the tenant smoked in the unit or is allowed to smoke in the unit or not, or whether or not they're allowed to have pets or additional occupants or anything along the lines of that. So again, like I said, you're essentially purchasing into a business that is already set up and already has the terms set. And while there's some wiggle room, we'll get into that in a moment, there isn't a lot, and it does require mutual agreement from both sides. So that's a really big thing to be aware of. And the question is, don't you need to sign a new agreement with the tenants? And the answer to that is generally no. You don't have to sign a new agreement. You can, and if everyone's in agreement to do so, then that's an option that's available to you, but it's not a requirement. And the tenant doesn't have to sign anything with you. They've already signed an agreement, and all of the rights and responsibilities of that agreement are transferred with the interest in the land as well. So that does move over to you regardless of whether or not you sign a new tenancy agreement. And you aren't able to necessarily raise the rent because you're purchasing the property as well. The rent that is in place generally is what's going to stand for that that tenancy. What's important to know about this is that when you are going through this, you are essentially inheriting all of the things that the previous landlord did right, but also all the things they may have done incorrectly. And when we look at those mistakes that might mean things like not having proper paperwork, or not having any paperwork for that matter. And it might mean that you have really low rent, for example, for that tenant, if the previous owner just had low rent. So when you go into purchasing it, you need to make sure that rent that's in place is something that you can abide by, that it actually works for you and makes business sense for you to enter into that agreement. Because again, it's not really much of an option for you at that point when purchasing the property. You don't really have any way around the fact that rent is set. So what should you get from the previous owner when purchasing a tenanted property where it is a revenue property? What should you get? Everything, really. You really want to make sure that you are getting all of the paperwork that is available. And that means things like perhaps the application for tenancy, the tenancy agreement, the condition inspection report, any dispute resolution decisions, notices to end tenancy, even if they weren't effective and they were canceled. It's important to have that history, caution notices, incident reports, and that's not an inclusive list. You want everything that could be in place for that tenancy. Because as I mentioned, again, what you're doing at that point in time essentially is purchasing into a business agreement. You're purchasing into a tenancy that is already in place with its terms set. So you need to know what those terms are. It's hard to follow terms of a tenancy if you don't know what's written. So ask for everything. so that you fully understand exactly what it is that you're entering into. So what do you do if the previous owner did not complete all the paperwork? So perhaps maybe they haven't done a move-in inspection. Perhaps they don't have a tenancy agreement in place. What does that mean for you? Essentially, that would mean in that case that again, you're purchasing that mistake and not having a move-in inspection, which generally needs to be done at the beginning of the tenancy before the tenant even moves in. So when the unit is vacant, you essentially are purchasing into that and by virtue of purchasing it, waiving your right to claim for any potential damage or cleaning that may need to be done at the end of the tenancy. We're not going to get into too much about how to claim for damage or anything like that, but that's an important thing to be aware of, is that if there is damage or cleaning at the end of the tenancy, the previous owner did not do a condition inspection report, it's fairly difficult to be able to claim for damage at that time, because again, you don't have that inspection that the tenant had participated in. And you can go through and do an inspection once you take possession, but the tenant doesn't necessarily have to agree to it. They don't have to participate at that point, because they've already moved in. This tenancy is already in place. And it could be questioned whether or not that notice is that inspection is even valid. So it's not something to rely on by any means whatsoever. Still, I would recommend that you do it, but again, not something to solely rely on. And the same goes with the tenancy agreement. If there's something in there that you would want as a rule in your tenancy, but the agreement doesn't state that, then it's not a rule of that tenancy unless both you and your tenant come to some type of agreement about that. So we take a look now at showing to potential purchasers. We're kind of going back, but we're looking at this more from a lens of where we are right now in COVID-19 and 2020. So showing to potential purchasers is, I mean, in normal circumstances, not always the easiest. It does require that you kind of get that tenant buy-in to make it easier, and that they make sure the unit is clean and presentable for actually showing it. The first thing that we want to look at is, are you allowed to show vacant units right now? The answer as of today, November 25th, 2020, is yes, you can. There is no order against that. And I say today because we don't know what next week, or even tomorrow for that matter, will bring. And certainly we are in, as we've said repeatedly, uncertain and unprecedented times. And there's a potential that could change at some point in time. Again, likely not for a long period of time necessarily, but it could certainly happen, where for a brief amount of time, landlords and realtors are not able to enter a unit to show it to potential purchasers. With that being said, while you are allowed to show the unit, you really want to do everything you can to limit entry to the unit. Right now, especially right now over the next couple of weeks, as is reiterated time and time again by our provincial health officer, Dr. Bonnie Henry, now's the time to really take those extra precautions. And if you don't have to show the rental unit right now, especially if it's a tenanted unit, then don't. If at all possible, use other ways to show the rental unit to potential purchasers. That might mean a video tour of the property. Perhaps go to the tenant at the beginning of the process and say, hey, we'd like to limit it, how many people come through, so we'd like to take a video of the rental unit. Can we do this? And if they say, you don't really need their permission, but again, it's good to try to get it. Get that permission, go in and take that video, and then you can use that to show it to potential purchasers. And again, hopefully try to weed out people who maybe aren't overly serious about actually purchasing the property. Photos also help, of course. An important thing, though, for both video and photos, is that they do not identify who the tenant is. And obviously, an easy way of doing that, or one of the easiest ways, is make sure the tenant isn't in the photos, but also look at what is in the photo. Is there something that potentially could identify the tenant, such as, say, they've framed and hung their degree up on the wall? Well, that could identify who that tenant is. It has their name on it. So things like that show personal information, family photos, those should be put away, or at very least not visible in the photos. I wouldn't rely on taking the photos and then blurring out those parts. One, that doesn't look all that great, and second, you might miss something. So really just take a very clear look and ask the tenant in advance, can you put away anything that identifies you, or you just flip that photo down. And again, that could mean just a family portrait that identifies them and has a picture of who they are then. So just anything like that, you want to make sure that you take out and it isn't visible. If you do need to enter a tenanted suite, then you need to take some extra precautions. And again, this is all related specifically to COVID-19. So hopefully those, some of this isn't necessarily relevant, hopefully next year even, but we don't know how long this is going to go on for. So when entering a tenanted suite, we want to make sure, especially right now, that you are wearing a mask, and the people that you are bringing into the property are wearing masks as well. That you wash your hands before going in, that you have hand sanitizer, that you try to avoid touching really anything. A kind of good rule to go by is ask the tenant to open all of the doors in the unit, so doors to the bedrooms and things like that, before even entering in. So that's one less service that you and other people have to touch. And then let the people who you're bringing in know that this is the case. Additionally, you are not allowed to bring more than 6 people in, and that includes yourself. So when we count that 6 people, that's yourself, as well as the people you're bringing in. So if you're hosting an open house, which now is probably not the time to do that, but if numbers go down, and we are still looking, and we do look at a time where it's maybe a bit safer, even then you really want to limit how many people are coming through at that time. A good way of doing this is also making sure that the tenant is perhaps not in the unit at that time, even if they're just outside waiting, or if you give them a gift card to a cafe, if it's safe to do so at that time. A lot of things, of course, have changed due to COVID-19, but really the key message on all of this is limit it as much as is possible. And when you do have to enter, take those precautions that have been repeated so many times by our provincial health officer, Dr. Brennan Henry, and through the BC Centre for Disease Control as well. So wear a mask, wash your hands, use hand sanitizer, touches few surfaces as possible, and keep your distance. So before we get into the Q&A, I just want to again thank our sponsors for today, Waste Connections of Canada. As mentioned, right now they are offering an additional discount of waiving the monthly fee on the first month, and this is valid until December 2020, so this year. You can contact Rob direct at 604-834-7578. Again, that's 604-834-7578. So we're going to go into the Q&A now, and I have the privilege of being able to introduce and bring on today a special guest, a lawyer that I have great respect for, Michael Juilliard. He's a real estate lawyer with Harper Gray and a Landlord BC board member. So welcome to today's webinar. Michael, I think you're just getting kind of set up right now.
I am. Hunter, can you hear me?
I can, yeah.
Okay, great. I'm trying to start my video, but it tells me that
I think you can now. There you go.
There we go. All
there
right.
we go. And I'm just going to stop the screen sharing so that it's just our faces.
Excellent. All right.
Welcome. Thank you for taking some time out of your day today to help with the Q&A session for this topic. It's obviously a very nuanced topic. There's a lot to be aware of, and truthfully, we went through a lot of information today, but there's a lot to it that you need to be aware of that's going to be outside of this, and that's why we brought in Michael Juilliard today. So,
absolutely.
I'm just going to start with a question for you,
sure.
And it comes down to ending a tenancy from a landlord standpoint. So you're the seller, you have a month-to-month tenancy, we'll assume that, and the new purchaser has asked vacant possession because they intend to move in, and they provided you with, and your realtor with documentation that is the case. You've served the notice. What risk, what is the liability, what should the landlord be concerned of if that new if that tenant doesn't end up actually moving out?
Right, absolutely. And I wrote an article about this recently. I encourage everyone to review, because I do both real estate transactions as well as real estate litigation. So when the deal works, I'm involved. When the deal is falling apart, I'm involved. And I've noticed, particularly since COVID has hit, that this has gone, and especially with the new rules with 12 months of penalty and that sort of thing, this has become a bigger problem than ever before. And so the big one, to go to your question, is you have a month-to-month tenant, you're asked by the buyer to give notice of to vacate, and you do so, and then the tenant doesn't move out. And so this is turning into a real problem, because the typical standard form real estate contract that real estate agents are using, it says nothing about what happens. It just says the buyer will have vacant possession on the completion date, and it does nothing to deal with the various issues that could happen. And so what's happening, for example, is the tenant is refusing to leave, maybe because in an example earlier this year is when the ministerial order prevented evictions of this kind. Many tenants were just not leaving because the government said they didn't have to leave. And what did that mean is buyers were using this as an opportunity to squeeze the seller, saying, well, if you don't give me vacant possession, I'm not completing and you're not getting your money. Or they were saying, give me 30 grand off for the purchase price for my inconvenience, or something like that. And that created a real problem, as I'm sure you can imagine. I think it's a really mixed question as to whether or not a buyer can back out of a purchase agreement because the tenant has left. I don't think so, but the case law is actually mixed in this area. And so what happened when the province instituted that emergency order is they didn't give an outcome to sellers about what to do, and it simply caused many sellers across BC to just breach their contracts. And so what I am suggesting now is, until agents, real estate agents, are given standard form language for how to properly deal with this issue, you're going to have to get a lawyer basically to draft a clause that sets out in the purchase agreement what happens under each scenario. What happens if the tenant doesn't leave? This should be spelled out. For example, it could say that the buyer still has to take possession, but that the buyer can claim their costs, their out-of-pocket costs caused by the late delivered possession. That's one issue. And it doesn't have to be that way. I'm just saying, put your mind to that issue. The buyer and seller have to put their mind to what happens. What happens if the tenant disputes the notice? Who pays for the litigation, right? Does the seller, because they're the landlord, or does the buyer, because the buyer is the one who asked that this whole notice be served in the first place? I mean, what's fair? I mean, the parties have to figure that out, and this has to be spelled out in the contract. Those are two major issues that are simply not dealt with in the agreement. And similarly, and I'm just going to talk very quickly because I know you asked me about sellers. On the buyer side, what if you give a notice? What if you tell the seller to give you vacant possession? The seller delivers a notice, the tenant leaves, and then you decide, oh, I don't want to buy the property, or I can't buy the property because of some other breach that the seller did. Well, guess what? You're on the hook for 12 months rent to the tenant, because the RTA says that if you don't move into that property after causing the seller to deliver a notice to tenancy, you have to pay 12 months rent. And so that's another issue that you have to discuss with your counsel to deal with. So this issue, which historically has been not really carefully considered by buyers, sellers, and agents, with all that's happened in the last few years with new tenant protection legislation, it's become a really big issue that now requires specific consideration. Sorry, that was a very long answer to your question.
Perfect answer.
There you go.
That's a great answer. And I know that going through some of the Q&A that has the questions that have come through, that actually answers quite I think a few of them. And I think one of my favorite terms that comes from a lawyer, or that you always hear a lawyer saying, is put your mind to it, put this to your mind and really think about it, consider it. And that's the important part. I think that's the key message to all of this, is before you get into this, you need to consider these points in advance. There's nothing worse than trying to make that, to having that understanding or realization down the road. And actually, you answered the next question that I was going to ask you about the compensation, and who pays that should you not actually follow through with that notice to tenancy.
Right.
And yeah, that is the important important part. So let's take a look. I'm just going to take a look at some of the other questions that have come through. And so, and I'll ask you this one here. When it comes to purchasing a property, and the paperwork, so that the tenancy agreement in place, how would you recommend the purchaser go about changing the name on the rental agreement? Do they need to change the name on the rental agreement?
It's a good question. The answer is you don't need to change the name on the tenancy agreement. The Residential Tenancy Act provides that when you as a buyer buy the property, you become the landlord. You go into the landlord's shoes, and there's no need to have the tenant sign some kind of acknowledgement to that effect. In fact, the tenant has no obligation to. You probably shouldn't ask them to sign something they don't have to sign unless you have good reason for it. And so you don't have to have the tenancy agreement changed. You simply take it over. Your conveyancing lawyer as a buyer should be arranging for the security deposit to be adjusted over to you, as well as the rent. But that's really the extent of it. I mean, if for commercial deals, you'll actually see a little bit more. You'll have the buyer request the seller sign an indemnity where they promise that for any matters relating to the tenancy before the buyer purchased the property, the previous owner will be responsible for that. And that's just to make sure that if there was some lingering issue that hadn't yet been sorted out when the previous seller owned the property, it gives the buyer someone to sue, basically, if there was some kind of problem. The classic example is illegal rents that then as a buyer you have recourse against. But in the typical residential, simple, single family context, you're not going to see that document used. It's nice, but you never actually see it. But there's not much you have to do. Your conveyancing lawyer should be handling the transfer for you.
And really what it comes down to is, as mentioned, you are purchasing into the agreement that is in place. And that might also mean that maybe you're purchasing into a situation where there is no written agreement. So I see someone had asked that. No written agreement is still technically an agreement. It's just not written. It's not obviously advisable in any way whatsoever to have that in place. But It does
I
happen,
agree.
especially when purchasing a property. That's
Yep.
probably one of the biggest things that comes up, is that there's just no written agreement. Well, no written agreement still is an agreement. Um,
And I guess,
so
in that scenario, sorry, a quick
yeah,
comment
yeah,
is
yeah,
that if you want to protect yourself when there's no written agreement, you can't, as a buyer, compel the tenant to sign a tenancy agreement. They're not going to
exactly.
sign it because they don't have to. But what you could do is seek out in the contract assurances from the seller about what's the rent, is it in default, are there any bad things going on with the tenancy, and that will give you some comfort that the tenancy is what it is, because otherwise the typical standard firm contract says you're buying the property as is, where is, unless there's a warranty in this contract. And so if the seller has made no promises about the state of the tenancy, you can't really fairly complain to the seller that, oh, you said the rent was $600 a month when it's actually only $400. They never promised you anything about it. So you're kind of hooped in that case.
Yeah, well, and that's exactly the point, is that you are purchasing into that that situation that's in place. So a question I can answer really quickly here that has come through is, in the event you have to apply for an order of possession, how long does it generally take for the RTB to actually have a hearing? And the answer to that is, that really depends on their backlog at the time, though generally order of possession hearings happen in about 6 to 8 weeks. They can happen quicker than that, and sometimes they do, certainly, but we're generally seeing kind of wait times of around that time frame right now. It is an ever-changing thing, and as mentioned, it does kind of really depend on the backlog at that time. Taking that question further, though, for you, Michael, what happens if that hearing date is past the possession date? Both the possession date on the notice and tenancy, but also the possession date of the sale purchase.
I know, and that's the subject of like 5 files I have right now. And it's a very complicated issue, because you end up getting, if it hasn't been properly papered in the contract, which is what I'm seeing is always the case, and perhaps if it was papered, I wouldn't have been hired in the first place, right? But the best thing to do is to have planned this in advance. What happens, for example, an agreement that the buyer still has to take possession, but the buyer can claim out-of-pocket costs, or it's really whatever you negotiate. It doesn't have to be one outcome or the other. Just put your mind to it, like I said. Now, I do have a strategy and tactic for that I want the audience to consider, which is that you don't, and Hunter, correct me if I'm wrong, I think you agree with this, but basically, when you serve a notice to tenancy for landlord's use, you don't have to wait until the effective date, i.e. when the tenant has to move out, to start the application for dispute resolution. That could be 1 or 2 or more months from now, and you'll be waiting that much longer for your hearing date. Whenever I'm asked to act in these matters, I always make the application for dispute resolution after the time period for the tenant to dispute the notice has elapsed, because the tenant may still move out. And if the tenant does, I'll withdraw the application. That's the end of that. But what it does is it gets you a hearing date much earlier than if you waited to see what the tenant does. It's like a prophylactic measure.
Yeah, and that's something that we covered earlier in the webinar as well. I mean, our general advice is, if you're very certain the tenant is going to be moving out, they've been very cooperative, they have somewhere that they're moving to and it works well, then you probably don't need to apply in that case. But as mentioned, you need to keep that in mind, that the longer you wait, the longer you're waiting for that hearing later on. And that can obviously cost you and the new purchaser, the new owner, significantly.
Yeah.
And it can cost your tenant significantly too. You're not necessarily doing them any favors by waiting.
And Hunter, I want to raise just another issue, which is I think the audience needs to know, which is that you can win at dispute resolution and get an order of possession, only to find the tenant has learned from a tenant advocacy website how to file a petition for judicial review and to receive a stay of the eviction order, which freezes it. And so you don't see this much, but I mean,
Yeah.
it happens, and you have to be aware you could win at arbitration and the tenant may appeal it, and that's going to be more delays. And so really your contract should contemplate all of this. You know, all the parties should know what they're getting into and what could happen, and it should be set out in the contract.
Yeah, so I mean, and that's a key part there, is that you know, you really should be contemplating this in advance. That's the, if we were to take one message away from today's webinar, it's consider this in advance. So let's just see. There's a lot of questions that have come in.
I know, I noticed. I know. You know, I'll say some of these questions I would love to be able to answer with them, but they're quite fact specific, that in such that I don't know the answer I would give is really fair to anyone or helpful. It really requires like a proper sit down with the lawyer. But
yeah, and in that, do you want to share your contact information?
Well, yeah, I see a number of people want to contact me, and I would much prefer an email, just so that I can manage when I get back to you.
We'll put that in the thank you email then.
Please, yeah,
sure.
Thanks. Yeah.
So I do have a question though, one that's come through that is actually really important, I think. Perhaps, you know, when you sell a tenanted property, especially if you're selling it as a revenue property and the tenancy isn't coming to an end, if you are already in a dispute with this tenant, and it might not be for an order of possession, maybe it's for a monetary issue, or the tenant has filed against you for some reason,
right?
And you have this dispute that is unsettled, so you haven't had the hearing yet, and the new purchaser is taking over. How is that handled from both the seller's standpoint and the buyer's standpoint? I know we're going over right now in time, so thank you for all those that are staying on. But we'll take a few extra moments.
Sure. Yeah, I have time, but so I hate to be repetitive, but the best thing to do is to explain to the buyer what's going on and to have an agreement with the buyer in the contract about how you're assuming responsibility for this litigation, that the buyer is okay with that, and you'll be dealing with it directly with the tenant. Similar, and that's whether or not the landlord started or is the litigation or is it responded. That's the best answer. But the default answer, like if there's no agreement, is that the previous landlord can continue that litigation if they're suing the tenant, and similarly, the tenant who started that litigation can still continue against the previous landlord. And so the sale should not affect that dispute. Sometimes there's a question about whether the new landlord should be dragged into it for one reason or another. And what should happen, I'm not saying this always happens, but what should happen is the arbitrator should decide who's responsible for it. So the arbitrator will see, okay, there's two landlords, disregarded a matter before the new landlord took over, so I'm going to find the previous landlord fully responsible for this. So the arbitrator will have to make a determination about that issue. That's why it's better to have it properly papered, so you're not wondering and who's the arbitrator going to stick the judgment against, right? So yeah,
definitely. Okay, well, thank you so much for taking some time today to join us in the Q&A today. Thank you to all of our participants who joined us today as well, and for your thoughtful questions. And stay tuned through the LandlordBC e-news for information about our next webinar coming up next month with our Director of Member Engagement, Kimberly Coates. Additionally, if you're not a member of LandlordBC and you're not receiving the LandlordBC e-news, you can sign up for our non-members e-news on our website, landlordbc.ca. And if you just scroll on down to the bottom, you'll see where you can sign up for the non-members e-news to stay up to date. Thank you all and have a wonderful day.
Thanks, Hunter.